Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. We are recording this on Wednesday, June 17th, 2026. In this week's episode, the millionaire at the center of a fatal boat crash tells his side of the story as his defense takes center stage. Plus, prosecutors reveal the alleged motive of the man accused of starting the devastating Palisades fire. But first, the sentencing of Gilgo Beach serial killer Rex Heuermann, as the family members of his victims had their chance to speak in court. Today, we are joined by Nicole Kazakov, a digital creator and law student at Suffolk University. Nicole, welcome. How are you?
I'm great. How are you? Thanks for having me.
I'm doing fantastic, and I'm very much looking forward to this because you're the first law student that we've had on. And I will tell you, you're probably going to be better at this than most lawyers because you're so in the weeds and fresh with all of the law, whereas I feel like you get out of law school and it becomes much more about, business cards and expensive lunches than actually understanding the law. So no pressure, but I'm looking forward to this conversation. Let's jump in then. First, out of Long Island, New York, over 3 decades after the start of a killing spree that haunted the area, Rex Heuermann has been sentenced to more than 3 life terms in the Gilgo Beach slayings. The serial killer pled guilty this spring to the murders of 8 women, leaving no doubt he would spend the rest of his life behind bars. However, Heuermann, who admitted to strangling and dismembering each of his victims, had the opportunity to address the court, saying only that he was, quote, responsible for all that was said in this room, adding, the words I say have no meaning. The sentiment didn't register as genuine contrition or an apology, leading the judge who admonished Heuermann as a disgusting and small man, calling him a coward. More importantly, victim impact statements were given, allowing those forever affected by Heuermann's actions to have their voices heard. Many spoke to the devastating losses they suffered after losing their loved ones. Some victims even directed their ire at Heuermann's family for profiting off of the deaths in their deal with the network streamer Peacock. While there's never a sense of justice in cases as tragic as this, it does, for the time being, close the book on one of the darkest chapters in Long Island's history. Nicole, these sentencing hearings are kind of a curious thing if you think about it. And this is not really a legal question. This is just kind of as a person watching this, as a person who's, invested time in understanding the pain that this man has caused. What do we really expect to get out of these? I mean, is this just kind of a moment for catharsis for the victims? Do we really expect to hear Heuermann say anything of value? What are your thoughts?
Yeah, I did watch his incredibly brief statement today. And I kind of, as you alluded to, I definitely think it's for the victims' families, the victims themselves. Kind of a cathartic thing. But yeah, not that I'm a seasoned attorney or anything, but I have never seen a judge react that way after someone's statement. I kind of thought it was warranted, though, I have to say.
Yeah, you know what? And I'm glad he did it. I think he kind of was speaking for all of us. I mean, we heard from the family members, and it was, as expected, just filled with continued rage and wounds that will never heal, but you can tell that they're still fresh in their psyche. But the judge kind of said the stuff that I would have liked to have said. As somebody who wasn't really directly affected by this, I would have liked to have called him a small man and say how he doesn't, nothing that he says is of any value. To that point, one of the things that's a part of his deal, as it were, that a lot of people have pointed to was the idea that he plans on, or at least has promised to, cooperate with the FBI behavioral unit and tell them about his thinking. Again, you think this is valuable, or is this just another opportunity for this man to brag about himself?
Yeah, so I wasn't really sure what to think of that, because as I understand it, the part of the plea was one that they would not prosecute for that 8th woman. which I don't really know how I
Right.
feel about that, although I understand court resources, all of that. But I guess, I'm just going to give a lawyer answer. It depends. Um,
Yeah.
it depends if he tells the truth. It depends if he just wants to talk about himself, which I would not be surprised about. I forget which psychologist, but I heard a psychologist talk about this saying, we're probably going to get a lot from him because he's the kind of person who probably loves to brag. I got away with this for so many years, all of that.
Yeah, and I have a feeling that this will not be the first time that these agents in that behavioral science unit at the FBI will have talked to someone like him, who's a complete narcissist and just wants to hear about themselves. But I imagine they can still glean some pretty helpful information. I mean, this guy, the amount of planning that he put into these murders is pretty staggering. Wouldn't you say? I mean, you remember that they call it the blueprint or that planning document that he had, really elaborate, not something, again, I'm not a FBI agent, neither are you, but not something that I've even heard about in following these types of cases.
Yeah, I was looking at the possible evidentiary issues, and that I looked at that and couldn't believe it. And I mean, I didn't follow the case extremely closely until semi recently. But yeah, I have never seen anything like that. And as we also know, I think it was his wife and daughter knew nothing of this either.
Get back to that point that you were making about, because just to be clear, he pled to 7 different murders. So 3 of those were charged as first degree, 4 of those were charged as second degree. Unclear as to how they made that distinction. But it doesn't really matter because the math works out anyways. They wanted to make sure he would spend the rest of his life in prison and not really have a chance of any kind of release. They've done that. There isn't the death penalty in New York. So this wasn't like a Koberger situation where they really had to give up something. They gave up nothing. But there was an 8th person victim who he admitted to, but he was never charged with, so never pled to, this 8th woman. Do you think they should have taken the time to actually go through the logistics of charging him, or is it enough that he admitted it? And again, this isn't really a legal question, just
Yeah.
kind of your take on it.
Yeah, I know. I was thinking about that earlier today. I mean, of course, you first have to think of the victim's family. I don't know if we've heard anything from them or about them or anything, but I imagine that, I mean, it's kind of like, well, what about me? What about our
Right,
family?
right.
At the same time, it may be that they're thinking, you know what? He's behind bars. He's going to stay there. That's good enough for me. Um, but yeah, with the minimal resources that, courts, prosecutors, defense attorneys have, maybe that's the best thing. But I do understand, the possible grief that the family feels for not getting to go through that.
Last question on this. They found more bodies in that area in Gilgo Beach, and they found there are other jurisdictions where he was known to travel or frequent, where they have unsolved cases. Now they have access to his DNA. There's a weird law in New York where they could not enter his DNA profile into the nationwide CODIS system until after he's been pled and sentenced. So that took place today. So now you've got all these different jurisdictions that are trying to clear some cold cases that they feel that he may be a part of. You think this is the end of it, or you think that we might feel that he's responsible for other murders?
I mean, I wouldn't be surprised, of course.
Right.
And they did only specify that this particular 8th woman they wouldn't prosecute for. So I don't think we've seen the last of him, unfortunately.
I think I agree with you. Somebody who was this, how do I put this? Somebody who seemed to receive this much excitement, pleasure. I hate to use that word, but the enjoyment out of doing this. Really evil person who enjoyed the act of the killing and the mutilation, but also the planning of it. You could tell. I just can't see that this was it. I was speaking with some other folks too who said that no, I think they said no, we think it's in the double digits. I mean, I would not be shocked if they're able to, now that his DNA is out there and they have a profile, if we might hear about other cases being solved. So we will continue to keep our eyes on this one. It's the end of a chapter, but I don't know if it's the end of the story completely. Let's move to Miami-Dade County, Florida, where the millionaire developer at the center of a fatal boating crash had his side of the story told after prosecutors accused the man of gross negligence. George Pino faces charges of manslaughter and vessel homicide after the nautical accident that took the life of teenager Lucy Fernandez. Pino struck a channel marker, while driving on the wrong side of the channel, capsizing the boat and sending many of the passengers flying. Witnesses in Pino's defense took the stand this week to describe the idyllic day that turned into a nightmare. Pino's wife, Cecilia, took the stand in an emotional testimony reminiscent of the defendant's outburst to begin the trial. Cecilia described how the Pinos had known the passengers from the time they were children, insisting her husband would never do anything to harm the children, especially driving if they were impaired. However, both adult Pinos did allow the underage minors on the boat to indulge in alcohol, which they allegedly provided. While Pino was never breathalyzed or given a blood test after the incident, additional witnesses on his behalf testified that the man didn't appear impaired in the resulting chaos of the crash. Ultimately, the decision will be left in the hands of the jurors, who could have a verdict by the time you're listening to this. Okay. This one, I'm sure you've learned this, at least so far in law school, about preserving evidence and how important it is for investigators to do the right work early on, because then prosecutors are going to be left with nothing at the trial stage. And that's really what we have here. I am beside myself with the idea that they never tested him, breathalyzed him, field sobriety tests. If they had to, go out and get a warrant for his blood to be drawn. But the idea that you had over 60 bottles of alcohol on that boat and the boat hits a channel marker and they don't breathalyze this guy, do you think there's any excuse for that? And is that going to be a major problem for the prosecution in this case?
When I saw that, I really wasn't sure what to think. I think that's going to be a problem.
Yeah.
If I mean, not much in any trial is black or white. There's a lot of ambiguity, a lot of fact finding for the jury. And without something as definitive as a breathalyzer or something of that nature, it's just going to be, I guess, up to witnesses to say, well, he was not slurring his words, he seemed fine, and all of that. So I just know there's no excuse for it in the short. Also, I think you said 60 something bottles of alcohol was on the.
Yeah.
Why would you not? I really do not understand that. It's going to be a problem, I think.
Listen, they can still try to make the argument that he was perhaps impaired. They didn't charge him with being impaired, but I think they are certainly trying to make that argument. But it just, to me, there's no explanation as to why they wouldn't get a test on this guy, even if they felt that he showed no objective signs of impairment. You've got a dead body in the water. Do the test. Who knows? I mean, if it comes back zeros, fine. But if it comes back with he's under the influence, that seems like something that you would want to know. And it's that type of evidence that goes away if you don't take advantage of it initially. So it just inexcusable on the part of law enforcement to me in this case. And I've never heard a really good reason as to why they didn't do it. But let's get to what they are trying, what they do have proof of. And one of those things is that he was going over 50 miles per hour at the time that he hit this channel marker. And I've seen the photographs and I've seen some of the presentation of the evidence in court. It's pretty clearly marked, this channel marker. They're trying to make the argument that going as fast as he was on the wrong side of the channel in waters that he's familiar with, and not seeing something as clear as day as this channel marker, that those all add up to recklessness enough for the crime that he's charged with. What are your thoughts?
Yeah, I mean, I'm sorry. Why the hell are you going 47 miles an hour when you have, 13 other people on your boat? Also,
Children that you apparently care a
right,
lot about and have known since they were kids. But go
grown
ahead.
up
Sorry to
with, you
interrupt.
claim that you raised them,
Right.
all this stuff. So I really, I mean, and they were talking about, I looked at some of the testimony talking about like whether the tide and then the direction of the sun was his vision being blocked. Again, none of that would have mattered, or it would have had a lot less weight, I think, for the jury if they had done a breathalyzer. But I guess we're not at that point right now. And I'm not like, was he in a no wake zone? Was he in open water? I tried to find it out, but the testimony was pretty long. But just, I could not get over that they didn't do the breathalyzer and then all these other factors come in.
Yeah. Yeah, again, it just is making their arguments that much more difficult because
Right.
now I think the trial is kind of becoming about was he intoxicated when that
Right.
really shouldn't be the question. The
Yep.
question should be was he reckless, intoxication or not?
Yep.
And I feel like jurors might be confused to the point that they get, well, I don't think he was drunk, so what am I supposed to do here? Accidents happen. And that's kind of the point the prosecutors are making is like, no, accidents don't really happen if you're following the rules. To me, what do you think about this? What if they made an argument of would we be having a discussion about impairment if you had a person going 60 in a school zone who blows through a stop sign? Because that's essentially what's happening here on the water that would have happened on land, right? You kind of wrap your head around the recklessness of it at that point.
Right. Right. I actually tried to, I didn't get to do a super deep dive, but I tried to look at like, is there a speed limit in that area? I
Yeah.
imagine there are in some places at least.
No, they do
So
have
that would
rules
have,
on what
right.
speeds you should be at in certain parts of those waters. Yeah.
And was there an indication in this area of that?
No, I think he was. I think he was in this channel where they were supposed to have a limited speed and he was above that speed.
Okay, so I feel like between that and going on the wrong side of the
Right. Yeah,
channel,
I didn't
I
add
feel
that part. He's also
like
on
you
the wrong
said,
side of the
right.
road when he blows through the stop sign. Right.
So like you said, impairment or not, I mean, maybe that doesn't matter, although there's this inevitable back and forth about that now.
Yeah. 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 The defense is going to done a good job of making that more of the question than what the question should be. Last question on this. He's had some moments in court. Now, there was one where he kind of got into it with the prosecutor. I don't know if that was witnessed by the jury at the time. I don't think it was.
I believe it was not.
But then there was his emotional kind of breakdown during opening statements where we saw, we've seen it all over the internet now where he was beside himself in tears that I didn't see. I don't know this man. I'm not trying to say he's faking it. I'm just asking you, if you're a potential juror, how are you viewing that? Is that getting to you, or do you look at that and go, I don't know, it doesn't seem genuine?
If you're not trying to say he's faking it, I am.
Okay,
I
good.
think that is BS. I don't even know if I'm allowed to say that on here.
Yeah.
I looked at the video so many times and I was like, interesting, no tears, and you're
Yeah.
hyperventilating, and then the paramedics get called in. It's this whole show. Um, Ridiculous to me.
Yeah.
No,
Yeah.
absolutely not. As a juror, I'd be like, seriously, you need to take some acting lessons because this is not. I find it hard, especially when your defense attorney presumably has told you you gotta keep it together.
Yeah.
No matter what emotion you have, you gotta just keep it together.
Yeah.
And knowing that going in, it was like 5 minutes or 7 minutes into opening statements, and he's already having a little meltdown.
Yeah.
And it's like, you have to control yourself, and you're doing this coincidentally enough in front of the jury. So I just find that a little bit hard to believe personally.
Let's say jurors feel like you do and they think it's total nonsense and he was faking it. Do they hold that against him enough to maybe turn the tide against him in a verdict here?
I don't know if that would change the verdict, but I think it's going to make him not very likable,
Yeah. Yeah. Which is not a good place to be.
which is not a good thing.
Right. All right, we'll keep an eye on that one. Like I said, by the time you're listening to this, there may be a verdict, but we'll continue to watch it. In the meantime, let's move to our final case here out of Los Angeles, where prosecutors have detailed the motives that drove the man accused of starting the Palisades fire. Jonathan Rinderknecht is facing a federal arson trial after the blaze that destroyed more than 20,000 acres, devastating the area. According to prosecutors, Rinderknecht spent New Year's Eve distressed over a failed relationship and driving Uber riders to their evening plans. Eventually, Rinderknecht had a drop-off near his ex-boyfriend's house where he allegedly hiked a familiar trail and started a fire that would eventually become the Lockman fire. Prosecutors characterize Rinderknecht as lonely and mad at the world. However, his defense claims that Rinderknecht is being scapegoated, for the LA Fire Department's failure to properly extinguish the Lockman fire. Eventually, due to weather conditions, the simmering blaze grew into the Palisades fire that caused incalculable destruction. Whether jurors will be able to connect Rinderknecht to the two blazes remains to be seen, but we will continue to keep you updated on this case as it continues. This is a very interesting question. This is a law school question, actually. This I could absolutely see coming up on a law school exam because it talks about, causation,
Yes.
and foreseeability, all of this stuff, right? This is fantastic. So I've always thought this was a major problem for the prosecution in this case. Just so everybody listening understands, he starts, according to prosecutors, but I think they've got fairly solid evidence that he starts a fire called the Lockman fire. That fire is responded to by LA Fire Department personnel, and they quote unquote put it out. But it is apparently smoldering in the root systems. Not like visible, but underground nearly. And it is reignited by the winds in Los Angeles that then cause the incredibly devastating Palisades fire. So he's saying, listen, even if you find I started fire A, you can't hold me responsible for fire B because one, I think he's making the argument that they're separate fires to begin with. And then two, even if they weren't, it really is the problem of them not putting it out, not the problem of me starting it, which is a little less of a convincing argument. Talk us through some of these issues and where you think the jurors might land on this.
Yeah. This is definitely an interesting one. I think another thing as well, which I found maybe would affect the jury in some way. I believe he called 911 over a dozen times.
Yeah. He's the one that would let them know about the fire.
Right. That he supposedly set.
Right.
So I guess I'm wondering, I tried to find what was the point of the first fire?
He's admittedly mad at the world and thinks that rich people are the cause of all his problems. So it sounds like a part of him wanted to cause some destruction. And that's the point the prosecution's making is, look, he got what he asked for. He got it a few weeks later, or a few days, I should say.
Yeah, I mean, I also think it's a powerful thing. It didn't seem like there was, I think there was cell phone data and that sort of thing linking him to starting the first fire. But I also think it's powerful when one of the parties says, look, we can't definitively say, we don't have the classic, DNA, that sort of thing. Obviously, It's not a victim crime or a single victim crime. But we don't have, DNA and that sort of thing that's definitive. This guy did it. But we have all these other things that say this started from a man-made fire. And we think that he made the first fire. So put that together, jury. But yeah, I do think there's definitely room for reasonable doubt at this point.
You do.
We haven't, I think so. It's going to take a lot for, I think, experts to explain going from generic to specific, what the science even is behind arson and all of that. And I didn't even know, maybe this is common knowledge, I don't know, that a fire could kind of linger below ground and then all of a sudden, okay,
yeah.
Good. That makes me feel better about myself.
Yeah.
Yeah. But yeah, I think that's a tough case. It's an interesting case.
It is a tough case. I think for the prosecution, it sounds like they have experts, at least, who can testify
Right.
to this, right?
Yes.
That let's, for the moment in our discussion, just say he started the Lockman fire, and that jurors aren't going to really have a problem with that because they've got his cell phone location. They've got him kind of being a pyromaniac type individual, anyways. They've got him being the only person in that location. The fireworks that they're trying to blame it on are nowhere near it. Okay, let's say they believe he started it. Now it becomes, should he be held responsible for the later fire? Prosecution is going to call an expert to say this is how fires sometimes exist, is in the root systems, and they can flare up later on. If that is true and jurors buy that, in my view, it becomes less about did he expect this other fire to take place, and more about, do we give him the benefit of the idea that they kind of put out the one? Like, you know what I'm saying? Like,
Yeah. Yep.
he started a fire, folks, and fires sometimes get out of hand, and you don't get the benefit of the idea that they may have stopped it almost all the way the first time. You are responsible for this first domino at all. If you hadn't started that first fire, we'd never be talking about any other fires. Do you think that is enough for jurors?
I do get the argument. Although if I was his defense attorney, I would say, yeah, this could happen.
Yeah.
This someone could start a fire, it could linger underground and erupt somewhere else. It could, but what evidence is there? What definitive evidence, what convincing evidence is there that it happened in this situation?
Yeah.
I do understand, you started a fire, period. We know that. But I do think the law school question, the causation is going to be an issue, I think.
Yeah. Yeah. Do you think, you mentioned this, do you think part of the problem is that fires in our kind of layman's perspective don't seem to have as clear as a beginning as we all might appreciate? What I mean by that is that, I see a fire and I go, how in the world are they going to know what started that? The thing took place over acres. Like, are you telling me they can trace it back to one guy lighting a match? I'm wondering if that might be the same thing here, because there were other fires that started during the Palisades fire. And why are they going to say that they know the Palisades fire started because of the Lockman fire and not some other reason? Is that kind of where you're going in your thinking for the defense?
Yes, definitely. And that's, the burden, that's all it takes, right? Is that little part of the jurors that are like, but do we really know this for sure? Like, why would I vote to convict if we really, it could be, but you really just can't say for sure.
Yeah. Yeah. Really interesting case. And it's sad too, because it caused so much destruction. I know that we want to be able to say that we found the person responsible for all of this, but we will continue to keep our eyes on that one as well. But Nicole, that is our show for this week. Thank you so much for coming on. Tell us, where can people find more about you? Do you got social media or a website you want to direct anybody towards?
Yeah, I've got Facebook and LinkedIn because I feel like I'm a boomer saying that. Just first and last name, Nicole Kazakov. My Instagram is Nicole_Kazakov.
Fantastic. I'm your host, Josh Ritter, who is a boomer. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can check out my new YouTube channel, Courtroom Confidential. And and of course, you can find all of our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.